BSides DC 2016 videos are brought to you by clearedjobs.net and cybersecjobs.com, tools for your next career move, and Antietam Technologies, focusing on advanced cyber detection, analysis, and mitigation.
All right, I'm Marcia Hoffman, and thank you all for coming out so early on a Saturday morning to listen to me blab on and on and on about legal stuff. I really appreciate you coming out. And feel free to come up a little bit if you want. I feel like the slides are a little bit small on the screen. So how many of you know me? Okay, have we met before? Not many of you. Okay, so I used to work for the Electronic Frontier Foundation. I was a staff attorney there for 7 years. And then I left and I started my own practice. And I consider my practice area to be digital civil liberties. That's how I describe it. So I'm interested in privacy, free expression, creativity, innovation, and I really am interested in hacking and in information security in general. And a number of my clients are security researchers. So I love conferences like these ones. I'm a big fan of everything you all do, and it's nice to meet you all. I didn't actually expect to talk about the crypto wars. I feel like every conference you go to these days, the legal people, at least all conferences I go to, the legal people are talking about the crypto wars, and it's a very important topic, but everybody's talking about it all the time. So I was going to do something really crazy and innovative and go in a totally different direction and talk about something else. But then there were some really interesting developments in the past few days, and I thought this is a great time to talk about what's new, and hopefully teach you all something that you don't already know about the crypto wars that I think is very important and something we need to keep an eye on. So to start out, let's talk about a little bit of recent history just to make sure we're all on the same playing field and in the same ballpark. And the place I want to start is not the crypto wars like 20 years ago, but actually much more recently than that. I think that the invention of the cell phone is a really huge moment in human history. And when you think about it, it's incredible that the iPhone has only been around since 2007. The vast majority of Americans at this time have a cell phone. It's incredible what an important part of our lives this type of device has become. Most of us carry it around with us all the time. It's one of the first things we reach for in the morning. It's one of the last things we look at night. It has information about our families, our business relationships, communications with pretty much everybody that we know, can have financial information, tracks your location all the time. I don't think there's ever been anything quite like it in human history in terms of the information that it reveals about each and every one of us. And of course, that makes it very interesting to a lot of people, including law enforcement. And that's one of the key things that we're going to talk about today. Now, as quickly as this little device has taken a key role in all of our lives, the law around how we treat this kind of information and we treat these devices has been a lot slower to develop. And that's pretty typical. Technology moves fast, law moves slowly. And there are a lot of reasons why that is. But one of the most interesting challenges, I think, in my work is that we see these really interesting new creations that are widely adopted by everybody and are in common use. And you have to do a good job of explaining to the courts what the implications are and why that's important. And judges are often people who are not early adopters, and they may not easily and readily get the implications. So it's a fun and interesting challenge, but it's something that you always have to think about and you're always struggling with. Now, that said, the courts are starting to catch up. And we've had a lot of interesting situations in which the courts have looked at questions involving law enforcement access to data on mobile devices such as smartphones. The issues that I'm going to focus on today involve the Fourth Amendment and the Fifth Amendment. The Fourth Amendment protects us against unreasonable government searches and seizures, all right? And the basic rule is that if you are engaged in an activity or if you're in a place that you reasonably consider private, as a general rule, law enforcement would need to get a warrant signed off on by a judge that says that they are allowed to search or seize evidence of a crime in that place. And there are exceptions to that rule. We'll talk about some of them today. But that's the basic rule. And we saw a number of cases over the past few years raising the question of when law enforcement needs to get a warrant to search your phone. And I think the most interesting of these cases involved the question of what happens when law enforcement is in the course of arresting a person. Are they allowed to search the phone? There is an exception to the Fourth Amendment requirement that law enforcement needs a warrant to search something in situations where the search is performed incident to arrest. So the idea is if you get arrested, law enforcement is allowed to pat you down. They're allowed to see if you have any weapons on you because that implicates officer safety. They're allowed to see if you have evidence of a crime on your person that you might easily be able to destroy, and they can take it away from you. And they don't need to get a warrant to do all that stuff, right? And so in some of these early cases, we saw situations where somebody's getting arrested and the officer finds a cell phone, perhaps in this person's pocket. And the question becomes, can they search that phone right there, incident to arrest, or do they have to get a warrant? And the government's perspective, of course, was, well, we have this long established rule that we're allowed to search things incident to arrest. Why would a cell phone be any different? And on the other hand, people said, well, a cell phone is different, right? There's a lot of information on there that implicates a much wider variety of privacy interests than anything else you might have in your pocket. And this question went all the way up to the Supreme Court, and the Supreme Court said law enforcement has to get a warrant to search a phone. They're not allowed to search it incident to arrest. There could potentially maybe be certain case-by-case situations where a different warrant exception maybe could apply, but as a general matter, a warrant is needed to search a cell phone. And basically the reason is because a cell phone, the Supreme Court says, really and truly is different. It is not like anything we've ever seen before. And so that was a very interesting development in the law, and I think that for many people who follow these issues, it was a big surprise. And it shows that even at the highest levels, the courts are starting to understand that technology is not quite the same thing that we've been dealing with for decades and centuries that we've been developing the law around up until now, right? The other legal interest I want to talk to you about is the Fifth Amendment privilege against self-incrimination. So the Constitution says that the government can't compel you to give testimony against yourself that would be incriminating, okay? So 3 requirements: government compulsion, testimony, and incriminating. And there have been a number of cases in the last several years that have raised the question of whether an attempt by the government to force somebody to decrypt data or provide a password or perhaps provide a thumbprint to unlock a phone raises these concerns. Something is considered testimonial when it reveals the contents of your mind. That's the general rule. And the courts have recognized that sometimes that doesn't involve saying things out loud. What it could mean is you've been asked to take some kind of an action, and that action itself would implicitly admit certain things. Like, for example, that you have control over something, or that certain information exists, or that it's authentic. And in those situations, if the government is trying to compel you to take a certain action, you can have a valid Fifth Amendment privilege that protects you from having to do that because of the implicit testimonial aspects of that action. And it's a little bit confusing, right? And I think that there are some blurry lines between what is testimonial, what is not testimonial, but we can talk about that a little bit later. Many of the cases that we've seen so far in this area have not involved phones per se, but we're starting to see that more and more. And this question hasn't reached the Supreme Court yet. It's just starting to kind of percolate up to the appeals court level, which is kind of the middle between the district courts, which are the trial courts, and the high court, which is the Supreme Court. So to further complicate all of this, the Snowden effect happened. So after Edward Snowden gave a tremendous amount of information to journalists, which then was ultimately published, a lot of tech companies decided that they wanted to take additional action to try to keep the NSA out of their systems and try to protect the data on their systems, which meant that encryption by default became much more widespread. It was built into products. It became less difficult for users to take advantage of. And in many cases, users were encrypting their data just totally by default because that's how the products at that point were built. And so to make the Fourth Amendment and the Fifth Amendment issues even more complicated, we threw a wide deployment of encryption into the mix. And so then we've started to see these questions emerge about what happens when law enforcement is trying to collect evidence of a crime that's encrypted, and they're not able to get around that. How do we deal with that? And this has been a topic of great discussion for a couple of years, I would say. You all may remember this Washington Post editorial in which the editorial board suggested that perhaps companies like Apple and Google might invent a kind of secure golden key that they would keep and could be used by law enforcement only when a court has approved a search warrant. And this led to a lot of discussion about whether it's a good idea or a bad idea to be building backdoors into the encryption in certain products. And that is a debate that is ongoing. So a lot of this stuff you probably are well aware of due to events in the news over the past several years. One of the things that's gained a tremendous amount of attention is the pressure that's been put on certain service providers to give assistance to law enforcement to get around some of these problems. And the clearest and most obvious example is Apple. I'm sure that many of you read in the news about a very particular situation in which the Department of Justice was investigating the really terrible and unfortunate incident in San Bernardino where a couple murdered 14 people, injured 24 others, and then killed themselves. And in the course of investigating the situation after the fact, the FBI learned that one of those suspects had a work phone that was an iPhone 5C. And the FBI wanted to see whether there was anything on that phone that might help in the investigation. The issue is that that phone was running iOS 9, which had encrypted the information on the phone and had certain mechanisms that made it so that if you attempted a passcode too many times, the keys to decrypt that information would be permanently wiped. So the government was in this tough spot where they really wanted to see the information on the phone, but weren't in a position to get it. And they had a valid warrant. By all legal rights, they should be able to get it, but they couldn't get it because of the security features that Apple had built into the phone. So what does the Department of Justice do? It goes to a court and it says, listen, we need some help here. Court, could you please issue an order under the All Writs Act to help us out? Now, the All Writs Act is this old law. I actually read last night that it was first signed into law by George Washington, amazingly, that basically says that the courts have the power to issue any orders that are appropriate and necessary to make sure that certain events occur as long as it's lawful and it's necessary, and no other law would make it happen. So the Justice Department says, listen, could you issue an order under the All Writs Act, basically so that we can execute our search warrant? And what we want you to do is order Apple to develop a special version of its operating system that would basically compromise some of the security features that are in place to protect this data so that we can decrypt it. And initially, the court ordered Apple to do it. And then Apple said, no, absolutely not. And they went to the mat on it. They lawyered up. They hired some of the best lawyers in the country. And they basically said, listen, if we have to build this software, this is going to be a big problem. We think this is going to put us in a position where we have to compromise the security in our products basically at large, because if we do this one-off thing for you, surely we're going to have to do this for everybody else who comes asking as well, right? And the government says, no, it's not like that. It's just, one-time thing. You're really making this something that it's not. And it was this huge public deal. I'm sure all of you probably read about this in the news. And then it kind of fizzled. And the reason that it fizzled was because the FBI found a private party, a security firm, that was able to help it get into the phone. And it said, hey, listen, we got this stuff we were looking for. We don't need this order from the court anymore. No harm, no foul. We're all done here, right? And so, we kind of end up in this situation where there's this, I would call it, at least publicly, it appears to be an uneasy truce where, certainly I think the government knows that Apple doesn't wish to be terribly cooperative with helping the government to access encrypted information that's stored on Apple products. And so, the government needs to think about how else to deal with that situation. And I think that this leads us to a place where the pressure becomes more diffuse. It gets shifted from the providers to the users of the technology, because that is another place where perhaps the government might be able to access this information, right? So here's the new development that I think is really, really, really interesting. What we have learned in the past couple of weeks is that there have been a couple of situations in which the government has gone to a court and said, hi, we would like you to issue a search warrant that allows us to go into a home and compel everybody in that home who we think has a mobile device that can be unlocked with a thumbprint, to give us, the word that the government uses is to depress their fingers and their thumbs on their phones, so that they can be unlocked. And this is the front of this filing. It actually appears to have been under seal. It's not 100% clear to me how it all came out. But I'm sure you all are going to have a hard time reading that. But basically, this is exactly what the government asked for. Authorization to depress the fingerprints and thumbprints of every person who is located at the subject premises during the execution of the search and who is reasonably believed by law enforcement to be a user of a fingerprint sensor-enabled device that is located at the subject premises and falls within the scope of the warrant. The government seeks this authority because those fingerprints, when authorized by the user of the device, can unlock the device. So we now get into a situation where the government goes to a court and says, give us the authority to go into a home and do this, right? You know, imagine you're the person in the house when they show up, or the people in the house when they show up, right? And they say, hey, listen, I have a legal order here that says that I'm allowed to have you depress your fingers on the phone to unlock it, right? Is it possible you might have a valid Fifth Amendment privilege against self-incrimination? I think it's possible, depending on the circumstances, but I think very, very few people are going to be comfortable in that situation trying to assert a privilege like that. And in the Fifth Amendment cases we've seen before, the timing was different. In those cases, what happened was law enforcement would seize a device, take it away, find that they couldn't get into it, and then would ask a court to basically force the person to decrypt the information. That person raises Fifth Amendment privilege, and then we fight over it, right? But, you know, a court gets to hear about it, and a court gets to decide. But when it's done this way, what this means is that I think we're going to see fewer challenges, because people, I think, are not going to be in a position in the heat of the moment to say, wait a minute, I think I have a valid constitutional privilege here to not do this. You know, I think it takes a special person to take that stand in that moment. So I think it really shifts the dynamics of things in a very interesting way. And I can see how, for law enforcement, there's a great deal of incentive to go in that direction. So what does this mean for the future? What do we think we're going to see? So I think we can expect to see more law enforcement efforts to force users to decrypt data on demand in the moment before their devices are taken away from them. Because after their devices are taken away from them, I think we get into a situation where the courts are in a better position to look at those issues and make a reasoned decision about it, hear both sides of the issue. Beforehand, if this all comes as the result of a warrant application, the court hears one side of the story, which is the side of the government. Doesn't hear from the user. For these reasons, I think these are situations that are going to be more difficult for the users to challenge in court than they've been in the past, which I think is concerning. And I think we're not going to see very many public battles over this, because a lot of it's going to be done in secret with approval sought to do it unilaterally and under seal by the government before it ever even happens. And yet, I have to say, I feel kind of optimistic, because I do think we don't need a gazillion battles to happen in court. I think that we only need a few of the right battles to happen in court. And as I mentioned earlier, I think that the Supreme Court and other judges are starting to recognize how important it is to be thoughtful about how we think about the legal implications of technology and the balance of power among users and government and private industry, and how we protect those interests and how we make sure that at the same time law enforcement can do what it needs to do, right? And I think that the more that the courts tend to think about this in that way, I don't think we need a gazillion challenges in court. I think we just need to make sure that it happens at the right times, occasionally at the very least, because then we have an opportunity to litigate it. So, I'm curious to hear what you all think about this. Yes?
My take on it is that if they can't compel you to type in your PIN code, then you should use PINs instead of using fingerprints. You can't change your fingerprint. It makes a horrible password, because once it's hacked, it's available forever. And so nobody should be using fingerprints on your phone. Fingerprints are a great username. It's a stinky password. And so I'm curious, am I right that if I put it in my code, I have the right to say, no, I'm not going to give you my PIN or my password, but the fingerprints they can compel?
So a couple of thoughts about that. I think you're correct that a password is more testimonial, I think, just inherently more testimonial than a fingerprint, because a password is something that is in your mind, right? Unless you've like written it down or you're keeping it in a password manager per se. We can talk about that later, of course, right? But even with a password manager, you've got at least one password that you know, right? And so it's that piece of it that's in your brain that's the important part. And I think you're right that on the whole, passcodes or passwords are better for maintaining your likelihood of being able to assert a Fifth Amendment privilege, right? I do think that there can be circumstances where a fingerprint would work. But it has to be the right circumstance, right? It's like they have to ask you the right question, and it has to be a situation where, putting your fingerprint on the phone would reveal something, right? So like if the government says, for example, unlock this for me, and you say, okay, here, I think what you're revealing that could have testimonial aspects to it, testimonial value, is that this is, that this finger will unlock this phone, right? So you have control over it. So I think that there could be testimonial aspects to that. But as a general matter, like the government is allowed to take fingerprints, is allowed to draw blood, is allowed to take DNA without Fifth Amendment implications because, those are things that don't reveal anything about what you know. They simply reveal who you are, right? So I agree with you that as a general matter, I think passwords are better. Two-factor is pretty great too. I think two-factor resolves both of these issues. But fingerprints alone, I think your legal protection in the Fifth Amendment sense isn't as robust. Yes?
So you said you're optimistic about how all of this shakes out,
Mm-hmm.
right? What in your research and your travels have you seen, do you feel would be the government's next step to try to erode this kind of privacy? Something that we as users can be on the lookout for so that we know what's coming. Chance favors the prepared mind.
Right.
So if you're prepared and you know what you're looking for, you're ready for that situation, what is something that we would be looking for them to take the next step and say, no, screw you, you're giving it to me whether you like it or not. Like, what do you see, what do you feel would be a value added for the government as their next step so we know?
So I think that the trend is going to be more in the direction of putting pressure on users, because I think, users are in a less strong position to fight back. I think the best thing you can do is know what your legal rights are and know enough to realize when you get into a situation where you could assert a right and be brave enough to assert it. I think for a lot of people that's really scary, right? And you think, in the moment, you think, oh my gosh, if I'm not cooperative here, maybe I just get arrested. Who knows? Who knows what's going to happen, right? But I think that we need to have some people who are willing to take that risk if we're going to be able to fight the battles. Yes?
In my limited understanding, you can still challenge information collected and processed through the court system as part of the case. What do you feel are the real negatives of interacting, again, not saying we should be compliant without legal representation, but providing the fingerprint, the data, and then challenging it in court during the trial process, the litigation process?
Well, I think that part of the issue is that if you give them, if law enforcement shows up at your home and, says, I have a warrant here that says you need to unlock this device, and you do it, I don't know that you're going to have a very good leg to stand on later to challenge it in court. Because, I think what they're going to say is, basically, you agreed to do it, right? I worry that one is going to waive their rights if they try to do that. And to make it even a little bit more complicated, there was a case that the Supreme Court decided a few years ago in which the court basically said, if you want to assert your Fifth Amendment privilege, you need to make clear that that's what you're doing. You're not supposed to just remain silent and not answer questions. You're supposed to specifically say, I assert my Fifth Amendment privilege. And so I think a lot of people will not do that in the heat of the moment, right? So I think that those are all things to keep in mind. And those are all things that are important to know if you ever find yourself in a situation like the one we're talking about. Know when that type of privilege is likely to arise, know if you're likely to have it, and realize that you need to specifically say you're asserting it. Yes?
So since Touch ID doesn't work the first time you power on a device, if you powered off a device and you knew they were coming, you powered it off, could that be viewed as like obstruction of justice? If you have an idea they're going to ask you?
I think it just totally depends on the circumstances. You know, I mean, how would you necessarily know they're coming, for one thing, right? You know, I think that the way that that would probably play out is if the government thinks that you did something to obstruct their ability to get the evidence that they're looking for, you know, they probably would tell a judge that they thought you did that, and if the judge believed that that was true, then you could be in trouble, right? So I think we're just about at time, it appears to me, looking at the clock on my laptop, but I'm going to be around. Feel free to come up and chat with me. I know a lot of you have questions. Happy to talk. Thank you.